All right. Hey guys, how's it going? Wanted to give you guys an update on a case that we have before the Texas Supreme Court and let you know where we are and what you can do to help and why it's important. Hey, Mr. Lunatic, how you doing? Uh, so there is a case. It's called Ferguson v. Department of Public Safety. And while I've been interested in this case for a long time, I've had the opportunity. And by the way, those of you that are watching this live, if you have questions, just hold on to them because I'm not going to be able to see them until I finish kind of my monologue here, and then I'll transition over to the chat so that I can answer your questions. But we have a case before the Texas Department of Public or the Texas Supreme Court. It's Ferguson v. Department of Public Safety. And let me just give you the history of it really quick. There's also, if you want to hear a video, you can go to John Filax's page. It's John, John, Filax, Filax. I think that's how you spell his, or say his last name. And he did an interview with Todd Ferguson, who is the plaintiff in this case. But quick history, and then I'll get into legal discussions. But before even all of that, if you don't want to listen to all this stuff, but you know, you're like, hey, if CJ says you need help, we're gonna help. We need help raising money to get a new attorney. If you want to know why we need to do that, you're gonna have to listen to the rest of this video because I want to make sure I explain it to everybody. But there is a link in the description of this video on how you can help donate. And honestly, time is of the essence. We need to raise this money as fast as we possibly can because the Texas Supreme Court is going to hear this case any day. We really don't know when it's going to happen. And so rewind a few years back to, and can everybody hear me fine? Make sure everybody can hear me first before I get into the nuts and bolts. Otherwise, I'm just talking to myself. I think everyone can, or they would have said something. So rewind to 2018. Everyone knows about Olmos Park by now. You know my personal story. But the reason that I got involved was because of all these other issues that we're now dealing with. Because all the case that's before the Texas Supreme Court right now is one of the reasons why I even went to Olmos Park, me and Jim, in the first place, to stand up for Second Amendment rights in that city. And essentially what happened was a couple of individuals, First Amendment and Second Amendment auditors, were in Olmos Park. Todd Ferguson walked, he went into a convenience store there. It's the convenience store. It's actually right across the street from where I got tased and assaulted by Chief Valenciano and his thugs there. And he walked into the store to get a drink, and he was open carrying a handgun, perfectly legal. The store guy, the person behind the counter, a Middle Eastern gentleman, actually, he might have even been Asian from India. I know a lot of people. India is a part of Asia, not the Middle East. So he was probably from India, but you know, either way, he's had a heavy accent, and so he asked Todd if he had a badge, asking if he was a cop. He said no. He informed him that you can't carry in here, and he's like, oh, okay, I didn't see a sign. He left, right? So he left. He's looking for the sign. He sees the sign. There is a sign there that's a 30-07, no open carry, but it's behind a trash can. That's why he didn't see it. And he's like, oh, okay, crap. Well, so he takes his shirt and he covers up his gun and he goes back in to use the restroom and get a drink. Well, the guy then tells him to leave, that he wants him to leave. So Todd leaves. And then Jack Miller went in, and there's video of him where he goes in, and the guy is on the phone with the police, explaining that there was a guy in there. Now he did even tell the police that, yeah, he left when I told him to leave, and he did the right thing by leaving once the person at the store told him to. So 4 days later, Todd gets arrested for trespass by a licensed carrier and outside of his home. and on a warrant. So apparently, Almost Park created a warrant for Todd. They arrested him on a Class A charge of criminal trespass by a license holder under 30-7. Now, as you know, in Texas, if you get arrested for a crime that is a Class B misdemeanor or higher, then you lose your license. Your license is suspended. The Department of Public Safety shall suspend your license. Okay. You are entitled to what's called an administrative hearing. And under administrative law, this is essentially where you're supposed to have due process whenever a right or something that is going to affect your life, liberty, or property is going to be invoked. Unfortunately, the way the law is written is that, and the way that the hearings are conducted is that the hearing is only there to establish whether or not an arrest took place. Obviously, Todd was arrested. Obviously, I've been arrested 3 times for crimes I didn't commit. And if you're an activist in any way, shape, or form, that the police are just going to arrest you because they don't like you. They don't like what you're doing, and they want you to stop because it makes their job hard because they have to answer a phone call. But in Texas, that's just the way it is. That's the way it is. If you get arrested under Texas law, 411-172, or 187, it's one of those two. No, 172 is those are the qualifications. 187 is suspension statute. So under Government Code 411-187, they suspend your license. And Todd went and he requested a hearing. And he got his hearing. And of course, the administrative judge, the administrative law judge, they're called, held the hearing. There was no evidence presented. There were no witnesses called. There was no cross-examination, no rules of evidence, nothing like that. It was literally to establish whether or not an arrest had taken place in order to give DPS the authority to suspend your license. Yes, the judge found it did. Well, at that point, you are allowed to appeal to the county judge, which puts the case out of the realm of administrative law and into the realm of civil law. And that's where you can argue the merits of the case. You can argue the constitutionality. The ALJ doesn't care. The administrative law judge generally doesn't care what the constitutional aspects of it are. He is there to administer the law, whether or not it's good or bad. And so he went to the court. Obviously, the county court found, just like the administrative law judge, that, hey, look, this is the law. It doesn't matter that there doesn't have to be a probable cause hearing. They don't have to prove that the charges are real. The law says if you've been arrested, until those charges are adjudicated and either thrown out or you're acquitted or even found guilty, you've lost your license. Okay, it's suspended. So Todd appealed. He went to the Court of Appeals. The Court of Appeals upheld the county court because, again, hey, look, this is what the law says. Okay. At the appellate court level, of course, it was challenged on due process grounds whether or not this law was constitutional, because there was no due process prior to the suspension of a fundamental right, which is a right protected under Article 13 of the Texas Constitution. 23 of the Texas Constitution and the Second Amendment of the federal Constitution, and really just our basic human right to self-defense. So it doesn't matter what pieces of paper say that were written by old white people. I thought I'd throw that in there. So the appellate court ruled with the county court and essentially upheld the suspension because, hey, look, that's what the law says. We don't think it's a problem, and that's when I came into it, and that's where Open Carry Texas came into it. Todd at the time had attorney Millie Thompson, who was a great civil rights attorney. She does a lot of pro bono work, and she's just a really good attorney. She does a lot for activists. I've used her at least on 2 occasions. A lot of the activists do. So last summer, when I was doing my internship between my first and second year of law school, I asked Millie if I could work for her, and knowing that she's a largely pro bono attorney, I said, look, you don't have to pay me. just let me work under you. I'd like to learn the ropes because this is the kind of law I'm going to go into. I'm going to do exactly what she's doing, which is protect the rights of people, protect the rights of citizens, protect the rights of those who can't afford to defend their rights. And that's what she does. And that's what I want to do. So I had the privilege and the honor of working for Millie last summer. And the first, of course, as you remember, this is when the COVID thing took over and everything was stupid and the courts were closed and all the office buildings were closed. And so I ended up largely having to work from my home and telecommuting essentially. And so she says, "Hey, CJ, I've got this this appeals case that we'd like to go to the Supreme Court on, the Texas Supreme Court. Are you willing, or do you want to write the draft for this?" Those of you that have known me since 2013, when I became a gun rights activist, know that one of my biggest arguments has been the stupidity of the fact that just getting arrested for a crime means that you lose your license. And this was made especially clear to me when I was arrested the second time in Austin, when I was carrying a toy pistol in protest of all the arrests that had happened across the state. And I was carrying a toy pistol and got arrested for criminal trespass at a place I had a lawful and constitutional right to be, which is our state capital, the one place out of many that has been set aside for us to redress our grievances under the First Amendment. And it took a year from November of 2013 to November of 2014 before the charges were finally dropped. I had to go to court every single month. We got a case setting or a hearing setting, and we'd show up at court in Travis County only to be told, "Oh, it's been reset for next month." And then we'd show up the next month, "Oh, it's been reset the next month." In the meantime, and this is a Class B misdemeanor, in the meantime, I've lost my license to carry. Now, I actually already lost it anyway because I was still dealing with, as you recall, this was between my first and second trial in my Temple case. And so I already lost my license anyway, but I had my first case had already been adjudicated as a hung jury and there was no guilty verdict, but yet I'd still lost my license until the prosecutors decided they were going to try me again. But let's just assume that didn't happen. And the only case before me was the Austin Capitol arrest. Well, it took a year for me to get those charges dismissed. And for that entire year under Texas law, now I didn't do like Todd did. I didn't challenge because I was already involved in another case as it was in Temple. Now I had this Austin case, which kind of compounded the problem with my Temple case. So I didn't go through the process of appealing the suspension of my license because it was still technically suspended under the Temple thing. And I had already lost my opportunity to challenge under the Temple arrest because I was a gun rights advocate in the past. I was a constitutionalist, but I wasn't an activist until I got arrested in Temple. And so I didn't really know all of the laws of Texas as well as I do right now. I mean, I could tell you anything about Texas gun laws now, but before I could just tell you the basics of kind of when and where I can carry. I couldn't tell you what 3802 is. I couldn't tell you what 46.035 meant. And I couldn't tell you what 411.172 was or local government code 229.001. I didn't know what any of that stuff was. I do now. I know whether it's the Texas Alcoholic Beverage Code, whether it's the government code, the local government code, the penal code. I know the law inside and out. So anyway, I did not challenge it. Todd did. But I would have lost my license for absolutely no reason. And in Texas, you cannot carry a handgun on your person outside of your vehicle or your private property unless you have a license. And so because of that, hang on one second here. Let me get this up. Because I didn't really pay too much attention to that. Well, for that year, from November of 13 to November of 14, when they finally dropped the charges against me in Travis County, I had no right to keep and bear arms. And I had no due process at all. Just the fact that I was falsely arrested because the cops didn't like the fact that they told me to do something I had no legal obligation to do. And knowing I had no legal obligation to do that, I refused to do it. So they arrested me and created this false charge of criminal trespassing. All right. So I have all since that day. That's when I realized and started paying attention and wanted to change the law about just getting arrested. And it was the 20 and in 2013 was the first legislative session where I was an activist, but we didn't even start Open Carry Texas until June officially, and really April was the first big rally because I was arrested in March. And as you know, the legislative session by April and May is pretty much over with. And so I didn't really get involved too much. As a matter of fact, there was, I think it was 711, House Bill 711, I believe, was the House bill. I might be wrong on that. Or 411, but that was the open carry bill way back then that the NRA refused to do anything about, which is why in 2013 we didn't get it. And then 2015 was my first legislative session as an activist, and this was one of the things I wanted to change, was the fact that it's wrong, it's unconstitutional that law enforcement is able to arrest you for no crime whatsoever, or even a crime. But they're able to arrest you, and just based off of an officer getting his diapers in a bunch and being offended that you stood up to him, you lose your right to keep and bear arms in Texas. Now, first of all, we shouldn't need a license, okay? Let's just get that out of the way. I know that you should not need a license, but we do. That's just the way it is. And so what Texas has done by relegating our Second Amendment protected right to keep and bear arms to having to obtain a license to carry, what the state has done, and it's a shall issue license. And because it's a shall issue license, the state has created what in legal theory is called a property interest. But there's also a liberty interest. And so, and these are important terms in the legal field, but I'm not going to bore you with all that kind of stuff. But they have created a property interest in that license, right? Because you cannot exercise your right, to keep and bear arms unless you obtain that state license. Well, so now fast forward to where we are, and Todd has now been falsely arrested because the law is very clear, obviously, that the signs have to be posted in a certain way. They have to be unobstructed. And he was asked to leave, and he left once he was made aware of the signs. So there's no crime, in my opinion, there's no crime that has been created. However, Olmos Park realizes that they've lost time and time and time again, and they refuse to drop Todd's charges. Now, here we are going on. Actually, I think we're already, because this was, we're past the 3-year mark. Todd has been without his license to carry for 3 years this month. That's when he ended up with this issue, which is what caused me and Open Carry Texas and others to get involved and go to Olmos Park to protest the way that they're treating gun owners. And what's interesting about this is, of all the cases that I've found when I was researching how to write this petition to the Supreme Court, the Texas Supreme Court, is there was one case that I was able to find where a guy had been arrested, and it took 4 years before the charges were dropped. So this guy was without a license for, well, and it didn't actually, I don't think he had a license, because that wasn't my argument. What we were using is that case as an argument that, look, if this guy had a license, look, it took 4 years for them to drop these charges. And it was because of lack of evidence. He didn't do what they had said he'd done. Well, now we've got Todd, and I believe he's now the second longest. If this takes a whole nother year, he will now have been the longest that I could find under Texas jurisprudence, where a person was charged with a misdemeanor crime and it took longer than 4 years. So Todd is nipping at the heels already of that record of being under suspicion of a crime for an extended period of time. So he's already at 3 years and has not had his day in court. Now, Millie got elected to serve as a judge in Hays County, which is great. Okay, now guess what? She ran as a Democrat, and I endorsed her because she is pro-liberty. Okay, and it was a Democrat position. It's kind of like in many districts, you have to, if you don't run as a Republican in some districts, you're just not going to win. Doesn't matter how good or bad you are. It can be the best Democrat and the worst Republican. It doesn't matter. It's a Republican or a Democrat district. And if you don't run as that party, whatever the leading party is, you're not going to win. Now, I'm not saying that she's not a Democrat. I'm just saying that I know after working with her and with her for so long, that she is a constitutionalist, regardless of whether she's got a D or an R or an I or an L after her name. Okay, so she's now a Hays County judge, which is great because I know that in her court, people's rights are being protected. All right, so going back to the Todd thing, there were only 2 other cases I can find where this provision of Texas law that 2 license holders had sued to challenge the fact that their license were suspended. But they were just challenging the fact that, hey, this is wrong. My license was suspended. And they did not, they took it to the Court of Appeals. They lost it, didn't go any further. Okay, so I found 2 appellate cases, just 2. And as a matter of fact, in one case, the judge at the county level and found exactly the way we're arguing, that the law is a violation of due process. Okay. And the appellate court overturned that. Look, this is what the law is. So the judge had it right, but he was overturned. And I think if that case had gone up to the Texas Supreme Court, this would have been fixed a long time ago, but it wasn't. And then there was another case where the court found the exact opposite, where the guy had lost his license. Look, that's what the law says. He went to the appellate court. That's what the law says. And then he dropped it. He didn't go any further. So I got to write this Texas Supreme Court petition challenging the validity of this law. This is an opportunity to fix what in 2015, when we were trying to fix it, didn't get fixed. In 2017, we were trying to fix, didn't get fixed. In 2019, we were trying to fix, didn't get fixed. And now this year, we're trying to fix and didn't get fixed in the legislature. Okay, we've been trying to fix this through the legislative process by getting the law changed in that way. It hasn't worked. Now we have Todd Ferguson, who's a friend of mine. I'm glad that I was honored not only just to be able to write this Supreme Court petition, because it's something I've wanted to change for a long time and I've been fighting for, but also I'm doing it on behalf of a good man, a good friend. And y'all know him as SA Ecstasy Prez on YouTube here. So we filed the brief, okay, and we're filing it on due process grounds, that it's a violation of Todd's due process, that he had a constitutionally protected fundamental right taken from him without a fair and meaningful hearing on the merits. Okay, it's taken 3 years now. It would be one thing if you were charged with a crime and you were able to, to go to court quickly, but we're talking about 3 years right now that Todd has not been able to carry on a Texas license. Here's the funny thing, and this is what I did as well, because as you know, oh, good golly, I see the I see that the peanut gallery has arrived. All right, and he'll talk smack, but he won't give you any facts. So Vincent Amnela Veritas. It's funny that he has something about truth in his name and he isn't spouting anything about truth. So the substantive due process and the procedural due process was not given to Todd in this case, and we are arguing that before the court. You can find in the link to below in the description, I put a link to the Supreme Court case docket. You can read all of the briefs. You can read all of the motions that have been filed so far to this point. You can read the petition to the Supreme Court and all the case law that's involved there, because there's a lot of good stuff in there. Sometimes a little bit dry because unfortunately what wasn't preserved at the trial level, and we're not sure exactly why this is, but the Second Amendment argument as a violation of the Second Amendment was not really argued and preserved at the trial level. The entire time, the argument was essentially on the due process violations, on the way that the hearing is conducted, and the fact that there's no access to a fair and meaningful hearing. So Because Millie got elected as a judge in Hayes County, she was required, and we've been waiting on. We filed our brief, I think, in August of last year, and the Supreme Court pretty quickly accepted it. Which, by the way, the brief that I wrote was accepted to the Supreme Court on first draft. Now, granted, I had taken a few weeks to draft the petition, but it usually the court clerk will kick it back because something is wrong. But I meticulously made sure that every single detail that the court required, and that every single footnote, and that every single citation, the formatting, everything was exactly the way the court was supposed to or what wanted a petition to be, so that it got accepted on the first shot. Now that's not bad for a law student, if I do say so myself. There's not much that I feel good about that I've done in my past, but that's one of those things. And then not only that, after they'd accepted it, that's the first hurdle. The second hurdle is that they care enough about the merits of the petition that they demanded that DPS file a reply brief. So DPS files a reply brief. It's crap, in my opinion. Their entire argument is essentially, look, this is the law. That's what the law says, but they completely ignore the due process violations. And that's one of the things also that the court does. There's a case called Matthews v. Eldridge that talks about what's required for due process. And the lower court didn't even apply any of the tests that the Supreme Court laid out for issues on due process violations, on whether or not someone's due process rights under the 14th Amendment were violated, and the Fifth Amendment. And so DPS submits its reply brief. Then we wait. That's when I found out. So we're waiting a few months, and then Millie gets elected, and we're like, oh crap, this is November of last year. And we realized pretty quickly that if we don't get a hearing before December 31st, she's going to have to recuse herself from the case. She's going to have to step down and end her representation. Well, then the Supreme Court asked for a brief on the merits. That's the next big hurdle. And that's actually kind of the last big hurdle before the Supreme Court decides to hear a case, whether it's oral or just a hearing on the briefs. So they asked for a briefing on the merits. We were freaking ecstatic. We got that done pretty quickly. Unfortunately, I had, and that was in December. Well, I had just left. I just started a between terms law class, and so I couldn't do it. And so Millie wrote up the brief on the merits, which, I mean, our petition was already, it laid everything out. So there really wasn't much more we needed to add. We had already addressed essentially what DPS had argued. And so we did the brief on the merits. The Supreme Court then told DPS, all right, reply to it. They replied to it. We replied to that. Again, just saying they haven't offered an argument that is substantial for denying due process. And that's where we sit right now. The problem is as of January 1st, we have no attorney if the Supreme Court decides that it wants to do oral arguments. Okay, if it wants to hear oral arguments, they have the decision. They can take the case just on the briefs, or they can and we've asked for oral arguments. We would like to go there and really hammer out the issues that generally aren't hammered out, because you've got to be very specific in your briefs. But when you're doing oral arguments, you can go a little bit outside of that and touch on some other things that maybe the judges have questions about that might not be included in your brief. In other words, like, what is the as applied problem? What is it overly broad, or do we need to rule on this on an as applied basis? So maybe the law is constitutional, but it's on the wide setting, but it's not constitutional as applied in this particular case. And so hopefully we get oral arguments, but to do that, we need a new attorney. Now that I've said all this, I've been on for 30 minutes telling you the backstory and how we got to where we are today. Here's the sell. The sell is we need to hire an attorney. It is incredibly difficult to find an attorney that will take a case that's already been adjudicated all the way up to the level that it's on, where the briefs have already been filed. Now, if we were at the stage where we needed to file a brief to the Supreme Court, it would have been so much easier, because then the attorney that we brought on and the attorneys that were willing to do it, but see, they're going to have to brief another attorney's case. And a lot of attorneys don't like to do that, because if they go there and potentially screw it up, there might be some liability there. They might not be as familiar with what went into writing it. Maybe they had a different idea of how it should have been written. Like, okay, this was a good brief, but I would have just done it a little bit differently. So it's very hard to find an attorney, one, that'll take a case that's already been briefed to begin with. And so we did find an attorney, and that attorney wants a $10,000 retainer, which this is a very good attorney. He's the only attorney that would take this is a $500 an hour attorney, and he's willing to do it for $400 an hour. That's still a lot of money. But we need to raise that money. And so in the description is our Give, Send, Go link. Please, if you can donate, I don't care if it's $1. Okay. If we can get freaking 10,000 people to donate $1, we're good. Now, the reason it says 11,000 on the thing is because that takes care of all the fees. So after all the fees from the processor and the money people and getting the money out of Give, Send, Go and the payment processor, it'll leave us with about $10,000, and that's what we need for the retainer. Here's the thing: we need to raise that money as quickly as possible, because literally any day, and I mean that sincerely, literally any day, the Supreme Court can schedule oral arguments. Now, generally, we're still going to have about a 30-day grace period, or at least a couple of weeks before the oral arguments happen. But the quicker I can raise the money, and the quicker we can get this to the attorney, we can breathe a sigh of relief. Because I guarantee you, if the attorney that we have takes the case, we're going to win. Okay, we are going to win. If you can't donate $1 for some reason, if you can't donate 10, 100, 50, whatever it is, then please share this information anywhere you can share it. If you've got an email list, share it on your email list. If you've got a Discord server, save it on your Discord server. If you've got Facebook, Twitter, Instagram, Parler, Freedom Lake, whatever you've got, Gab, MeWe, share the link to the fundraiser. And the quicker we can raise this money, just the better. I'm here in law school. I would argue this case myself before the Texas Supreme Court. I don't think they'd let me, because I'm not a barred attorney yet. Who knows? Maybe I could probably get an exception. I don't know. I could probably not as a pro se, but as a representative that's not paid by Todd. But I'm not in Texas able to argue that. Otherwise, I'd try. I'd fight that fight, and I'd argue it myself, because I know this case inside and out. But we need to raise this money. We need to raise this 10 grand to hire this attorney quickly, so we can get the attorney spun up and get him ready to go. Now, let's say that, because I've already raised, let me see what we're up to right now. My other screen here. I think we raised like $600 or something. So we have raised, as of right now, $745. Okay. Any money, if the Supreme Court says that they're not going to do oral arguments, and we don't need an attorney because they're just going to do a hearing on the briefs. If that's the case, all of this money, 100% of this money that we're raising, is going to go towards Todd's criminal defense. So the criminal attorney that is helping him in this case that's even created this constitutional challenge. Okay. So the money is not going to go to some weird place. Either way, it's going to go to Ferguson's attorneys, whether it's his civil attorney, which is what we're raising it for as Open Carry Texas, whether it's a civil attorney for this purpose, or if one of two things happens. If one, the Supreme Court says, okay, we've scheduled the case to be heard on this day, but we've denied oral arguments. Well, we don't need an attorney at that point. Then all that money will immediately go over to Todd for his criminal case. Or if, they do schedule oral arguments, but we haven't raised enough money to get an attorney, then at that point, any money that we've raised up to that point, even if it's $9,900, I think if we get close enough, I could probably convince him to even slash his prices a little bit more if we can get close. Then that money will still go towards Todd and his criminal case. Okay, so one way or the other, that money is going to go to the Ferguson case. And that's what I need your help with. We have a chance now to do what our pissant legislators have not done for at least the last 6 years. And that is fix the unconstitutional gun laws that are on the books. Texas, and if you go and you read the case briefs, okay, and read my briefing, the petition, let me see what it's called here. When you open up the link, you'll see what's called a brief on the merits and a petition for review. The first four things under the appellate briefs are going to be brief on the merits respondent, that's DPS, brief on the merits petitioner, that's us, response to petition, that's DPS, and then you're going to say petition for review, that's us. If you read petition for review, that's the one on June 8th, so it wasn't August, it was June 8th, and you read that, you're gonna read in the petition that I wrote, in the footnotes, I included the laws of all 50 states to show that Texas is the only state in the entire country, with this kind of law, that if you are just arrested for a Class B misdemeanor or higher, you lose your right to keep and bear arms. Literally, we are the only state in the union that has this unconstitutional law. The only one, not California, not New York, not Illinois, not Maryland, not DC. No, Texas, the only state. And I gave in my brief, I listed and cited, because I researched all 50 state laws about how do they handle licensing. Now, California is the next state, is the only other state besides Texas that will suspend a license for a misdemeanor. It's the only other state that will suspend for the arrest of a misdemeanor. However, the arrest for the misdemeanor must be a specific misdemeanor crime of violence or domestic violence. And generally, it's domestic violence. Now, there are many, many, many other states, and I saw someone say South Carolina as well. There are many other states that will suspend your license for a misdemeanor conviction, okay? If you get convicted, but not for an arrest. And there are many, and I don't remember specifically, if you go to the brief, I did list the South Carolina law. So I don't remember exactly where South Carolina falls on this or other states, but essentially there has to be a conviction of a certain types of misdemeanor. Generally, they involve domestic violence or they involve a gun-related crime, okay? If it's a gun-related crime, your license is suspended. If it's a domestic violence, your license is suspended. That's what the vast majority of the states do, and that's based on a conviction. California is the only state that will suspend on an arrest. Now, I'm talking about misdemeanors here, okay, not felonies. If you get arrested for a felony, it doesn't matter. All 50 states, you're going to lose a license if you have one. But in California, it's only limited to certain misdemeanors that would make you ineligible. Okay. There is a bill that's been filed. If you go to opencarrytexas.org, click on that bill tracking link that's at the top of the page. And there is a bill that would get rid of a lot of these unconstitutional exceptions to when you can have a license, that would actually make us a better state with regards to, essentially what it says is, as long as you can legally own and possess a firearm, then you qualify for a license, which means it gets rid of this unconstitutional, if you haven't paid your income taxes, if you haven't, well, we don't have income taxes. If you're behind on your taxes or you're behind on your child support in Texas, you lose your license. If you get arrested for a Class B misdemeanor, you lose your license. And what's interesting is in my brief, I listed several absurd misdemeanors that we have in the state. Do you know in Texas, if you own more than 6 dildos, that's a crime because you can be charged with trafficking and obscene materials? Yeah. So if you own 6 dildos, that's a crime. If you fail to vaccinate your pets twice within a year, that is a misdemeanor crime. If you litter more than 5 pounds of litter, and of course you're convicted of it, that's a misdemeanor crime. Graffiti is a misdemeanor crime. So we tried to make the brief highlight all the absurdity of Texas gun laws, and there are some bills that are going to fix that. Okay, but what we need you to do, is go to the Give, Send, Go link at the bottom, and please donate and share everywhere you can. Send it to your emails. It doesn't matter if it's in Texas or not. As a matter of fact, when what's his name, John Filex did the interview, he lives in Florida, I believe, and he's highlighting this. And everyone in the country knows, because of Texas, what our laws are related to stop an ID because of the way Texas is. And supposedly they think we have good gun laws, and we can make that happen. We can make that happen with your help. Please go to the Give, Send, Go link. All right. So that's my pitch. That's where we are. There's not a lot I can do from where I'm at in law school. I'm nowhere nearby. And so I've been trying between my studies, and I'm also now our local chapter of the Federalist Society. I'm also the chapter president. And so I've got duties with that, trying to get some good speakers onto our campus. As a matter of fact, I've got James Dwayne is going to be one of our speakers here coming up. He, you might remember his video that, and I highly recommend you read this book. It's not very thick. It's about $10 on Amazon. It's free if you have a Kindle, or it's like 99 cents if you have a Kindle. But he's got that viral video on YouTube. It says, "Don't talk to the cops." You've probably seen that. He's a professor out at, I can't remember where it probably says on here where he's a professor. Regent Law School. And so I'm bringing him out. Anyway, long story short, with law school, with doing my Federalist Society duties, as well as all the other stuff we've got going on, I'm also trying to coordinate this attorney thing. So really, you'd be doing me a favor if we could raise this $11,000 today, because then I can just drop this off my plate and know that it's in good hands. I'm worrying because this is my baby. This is Millie's baby. This is Todd's baby. And we have a chance to make case law in Texas. Okay. And we have a very good chance. All right. So let me see if there's any questions here in the chat. And if you've got any questions, just, let them go. Let me have it. It can be about anything. It can be about the case. It can be about whatever your questions are. So let's see. I'm about to lose my LTC to back taxes because of my ex-wife. Yes, Texas laws do suck. But 123 Senior, I can tell you that there is a bill that has a really good chance of passing that will get rid of that requirement or that exception. So hopefully that thing passes. If you want to know what bill number that is, go to opencarrytexas.org, click on the bill tracking link, and go down there and look for it. You'll find it. When will you be done with law school? I've got another year left, unfortunately. I will take the bar in July of next year. So not this summer, but next summer, God willing. And I'm going to study my ass off so that I only have to take the bar once. I will be an attorney by next summer. All right. In Texas. And I will be doing a lot of pro bono and a lot of this kind of work, civil rights type work. Hey, thank you, Stephen. All Texan. I'll tell you what I'll do, all Texan, is so all of we've kind of got two things going on right now. So I'm just going to ask you this question. If that's what you want, I can move your donation over each month. But we are also the donations, 100% of the money that I'm getting through Open Carry Texas, not the Gifts and Go, but through Open Carry Texas, the PayPal, that's all going to our legislative efforts. That's all going to paying for gas to get to Austin. Once the hearings start, sorry about that. I don't know who this number is that keeps calling me. I think it's a spam. And so all of that money is going towards our legislative. So it would take away from our legislative fund. If that's what you want, that's fine. I'll do that. Just let me know. Okay. Just let me know. But we kind of need two funding streams at this point. We need the attorney and we need that. Hey, thank you, sir. Yeah. All right. So yeah, and I know you guys miss my videos, and I miss doing my videos. I miss doing activism stuff. But if you ever decide to go to law school, you're going to find very quickly that it is a highly political social justice nightmare. And it's so regulated that the slightest, I can't afford to have any issues, which is why I haven't done any activism, because I can't really afford, I don't mean monetarily, I mean, I can't afford to face a committee and explain, even if it's a bogus arrest that gets thrown out. If I even get a traffic ticket, I have to report it to the university, and this is every law school, and I'm going to have to explain it to the bar when I have my bar hearing, every time I've been arrested, all that kind of stuff. And so I am intentionally not doing activism, and I know I'm not doing a lot of videos because I need to focus on law school, because if I get kicked out of law school, it doesn't matter. All this has been for nothing. And so I'm making the sacrifice of activism while I'm in law school so that I can become an activist lawyer and fight it that way. But if I can't become a lawyer, this is all for nothing. And so believe me, I miss making videos. I miss going out there and challenging the system and standing up for people and arguing and all that kind of stuff. But I'm going to be arguing in a courtroom here pretty soon. All right. Let me see if there were any other questions. Yeah, 2021 will be the year that gun rights are systematically dismantled. You know, it's funny because what happens this year is probably going to affect my firm, because I'm going into business for myself. I'm not going to work for any other firm. I'm going to work for myself. And so when I become an attorney, I have a feeling I'm going to have a lot of work cut out for me, because I'm going to be challenging Biden's gun laws. All right, Amtank. I'm not sure what you mean. Excuse me. I'm not sure what you mean by a Barker hearing. Either I haven't covered that yet in law school, or it's the reference isn't cueing something in my head yet. Yeah, exactly. I'm not going to try. I'm going to try not to attract too much attention. And I'm telling you, here where I go to law school, there are bills out there right now that are going to quickly, if they pass, will turn me into a felon anyway, just because of what I brought with me to law school. And so it's going to get ugly one way or the other. I just hope I can last a year, get out of here before those laws pass. Yeah, Lynn Wood is a good example of what happens when you speak your mind. Oh man, I'll tell you what, Bentbo, they've already found out where I go to law school and tried to cancel me and tried to get me kicked out of law school. They've believe me, I've already had to answer for being a Proud Boy. I'm still in law school. It's interesting when you have to provide evidence, and you're not going to find evidence that I'm some kind of white supremacist or that I'm in some white supremacist group. The evidence just doesn't exist. So, hey, Skip, what's up, man? How's the baby? Well, I guess it's not a baby anymore, huh? You got a little toddler there now. I need to see you need to text me a picture of your toddler. I need to see what your babies are like. Actually, send me a picture of your whole family, Skip. News Now Houston, what's up, man? What's up? What's up? Hey, I need you to spread the word too, brother, about this fundraiser so we can get Todd's case going. 7 months old. Why did I think your baby was older than that? Oh wait, is that your second? Skip, is your 7-month-old your second baby? I thought you had an older baby. I'll tell you, time is just flying in law school. It feels like it's only been a few months, but I've been in law school. I'm about to finish my second year of law school. I can't believe how fast it's okay. That's what I thought. Okay, so I need to see a picture of all yours. All right, Zafarius Collins, go to, and if you don't see the link underneath this video, go to givesendgo.com/defend-the-2A, the number 2. givesendgo.com/defend-the-2A, the number 2, not the word 2. Yeah, Hannah was the one I remember. Okay, that's right. So yeah, I need to see some pictures, brother. Either email or text me. You should have my number. Hey, Sharp, thank you for sharing that. I really appreciate it. Literally, if all you have is $1, I'll take it. Okay. And if you can convince 10,000 other people just to give $1, we're done. That's it. If you can convince 10 people to give $1,000 or 100 people to give $100, even better. Yeah, I know, brother. I'm banned on Facebook, so you can't find me on Facebook. You can't find me on Twitter. You can't find me on Instagram. I'm banned on all those. I'm about to get banned on TikTok. I've already got like 3 strikes against me for stupid stuff, man. Just absolutely stupid stuff. Hey, thanks, Emmanuel. I appreciate it, brother. Thank you. All right, I don't see any other questions here. I'll tell you what, kids. I'll skip. Man, so my grandson was born in July, which means he's about the same age as Paisley, I bet. I don't know, when was Paisley born? But you can find me on Gab, but I don't use Gab. I use Freedom Lake. I'm on freedomlake.com. I do have a Gab account. I literally do not use it. So if you contact me there, I won't see it. If you sent me something, I won't see it on Gab. I'm only on Parler and Freedom Lake right now and TikTok. And I've already had July 14th. My grandson was born July 4th. How's that? Little patriot baby. And I was born March 2nd, which is Texas Independence Day. So I was born on Texas Independence Day, and my grandson was born on American Independence Day. Yeah, so they're about the same age. I love it. Anyway, I could talk forever about kids. I don't want to bore everybody here. But I am loving being a young grandfather. And my grandson is learning to crawl now. He's scooting all over the place. It's awesome. Yeah, BitChute is good. Hey, Zavarius is also a Texas Independence Day baby. Congrats. All right. Hey, Ogden, Utah Cop Watch. What's going on? Good afternoon. Okay, so I'm going to go ahead and end this. There's no sense in actually, I'll scroll up a little bit further to make sure I didn't miss anything earlier before I just hang up. I'm not seeing anything. Rachel Menard, I appreciate that. I don't think I'm very charismatic, but I'm passionate. I don't know about charismatic, but Rachel, I appreciate the compliment. I do. Most people call me an asshole. I mean, I've already gotten several complaints at the school from liberals who don't like the fact that I speak my mind. So, hey, thank you, Zafarius, for saying that. I appreciate it. Okay. So I think I got everything. I think I answered all the questions or anything that was kind of directed at me. I think that requiring a license and a background check is also a deprivation of rights under color of law. Unfortunately, the stare decisis, or what the Supreme Court has said, well, actually, they haven't really ruled on licensing yet. But I can tell you that the Supreme Court would likely rule against the Constitution and say that the state has a compelling interest in licensing, provided that the licensing is not so burdensome that it essentially negates the Second Amendment. That's how I can imagine that argument being, that requiring a license. But really, the trajectory right now of this country is going towards constitutional carry. We just had Montana went to constitutional carry, even though they were kind of a constitutional carry state before, except the cities were allowed to ban unlicensed carry in the cities. But now that's gone. So Montana is officially. Indiana just passed, and it's likely to pass the Senate and the governor. But the House just passed their constitutional carry bill in Indiana that abolishes the license. And so I think the trajectory of the country, in the majority of the country, is towards making the licenses voluntary, which is good. Now, I think what you're also seeing at the same time is the uber liberal states going the exact opposite direction. So while the bulk of the country is going towards constitutional rights, you've got states like New York and California and even Virginia now and Illinois going the exact opposite direction and making it even harder than it already is. So, but I do believe that it is a deprivation of rights under color of law. It's just going to be a hard argument. Is this donation a tax write-off? Unfortunately, it is not. Mainly because Open Carry Texas is a 501c4, so we are a nonprofit, but we're not we're not one of those that. But when I'm done with law school, this is what we're going to do, and we're trying to do it before then. I mean, we've been trying to do this for about the last year and a half. Unfortunately, we made the decision to do this about the same time I got accepted to law school, to create a PAC, an Open Carry Texas PAC, so that or nonprofit, excuse me, a 501c3, not a PAC, a 501c3, so that any donations are tax deductible. And of course, the 501c3 will just do judicial type stuff, helping with lawsuits and creating lawsuits and defending the Second Amendment instead of actually lobbying and stuff like that we do for. So unfortunately, no, it's not. Are you going to a state school, and could it actually block white supremacists from joining if it is a state school? I would say no, Silicon Player. I would say that legally, constitutionally, a racist has just as much of a right to access the education system as people that aren't racist, or what they call white supremacists. The problem is, what is a white supremacist? Hell, I've been called a white supremacist, which tell the people that I play spades with, who none of them look like me, that I'm a white supremacist. Makes no sense. But I think there's an argument that can be made that they can't block you just because of your opinion on that. So, I mean, I think a law school might be able to, because it shows a lack of judgment. I think it would, if they could prove that you were actually a white supremacist, it could show a lack of judgment for getting into a law school. And there's a lot of rules that relate to not only law schools, but the profession of attorneys as well, the legal profession. Thank you, Melissa. I appreciate it. How can the states create new laws restricting the 2A when the states agreed to the 2A not being infringed? Not only that, even if they didn't agree to the 2A not being infringed, it's already been incorporated to the states under the McDonald case. So, as you know, Heller made the right to keep and bear arms an individual right, and the McDonald case that followed incorporated the Second Amendment, the states under the Second Amendment. So that's how they do that, Skip. It really is an intellectual gymnastics game that they're able to regulate the 2A to the extent that they do. Let's see. I heard they are coming for white supremacy in the military, whatever that means. I'm telling you what, General Austin, well, now he's Secretary Austin of the Defense Department, is about one of the, next to General Honore, who's even worse, is one of the worst generals. I didn't get a retirement award because of that guy, because I filed a congressional against him, and he wasn't very happy about it. And I won because Fort Hood had instituted a policy requiring troops, thanks to me and others, that if a police officer demands identification, that soldiers assigned to Fort Hood and 3 Corps will provide either their driver's license and or their military identification card. And it didn't matter why. If the cop said, "Let me see your ID," the general order said you're required to do that. So I challenged it. The Army told me no, the general's allowed to do that. So I went and I filed a congressional, and the general order had to be rescinded because it violated the Fourth Amendment rights of soldiers. And so because of that, the general refused to sign my retirement award. So I spent 21 years in the military and got nothing for retirement. Now my unit said, "Hey, we'll do an ARCOM. We can approve that, an Army Commendation Medal. We can approve that without the general." I was like, "Don't even freaking laugh at me." All right. Okay, that's everything. I did SCOTUS not talk about OC being okay? SCOTUS has not. The Supreme Court has actually not talked about open carry yet. There is no case law at the Supreme Court level. There are several circuit court decisions on open carry, and there is a conflict between the circuits. So eventually the Supreme Court is going to have to rule on whether open carry is a constitutionally protected right. Okay, Garza, what's up, brother? Haven't seen you in a long time, Mark. I hope you're doing well. I'm going to leave you guys at that. It's we're over an hour now, and I don't want this to be too long. Again, the links, if they're not below, I'll fix it as soon as I make this thing go live. You guys take care. Be safe. Be free. Just because you don't see me doesn't mean I'm not out active and doing stuff. I really am. There are several cases I've been helping with as a law student with attorneys around the country. Yes, including Rittenhouse. And other cases. So, for example, there's one in Nevada I'm helping with. And anyway, so I've offered my expertise, at least my research skills, which is pretty much all I can do. Yeah, hey, Zavarius, I think you can send it as a super chat. And as a matter of fact, any money I raise from super chat, I will donate. And any money I have right now, I haven't even looked. I don't look at my super chat until I need to raise money for something. I'll go and look at how much money I have in my account, and any money that's in there, I don't care how much it is, I will donate to the attorney's fees. Okay. So yes, absolutely. It's not allowing me to send you the money. Oh crap, that sucks. Hey, Zafarius, also, I'll tell you what you can also do if you go to opencarrytexas.org and you send a donation through there, and you just make a note that this is for the attorney's fees. That way we can separate it from the other donations that we get. Then I would appreciate that. And yes, Matt, I did get your donation. Thank you very much. I appreciate it. Okay, guys, that's it. Thank you. There it is. Thank you, Zafarius. I will add that to the Defend the Second Amendment. That's $15 going there. I appreciate it. And I don't know how much I have in there, but whatever I have in there, I will download all of it into the account. And I'll even let everybody know how much I don't want to toot my horn. Just know that I'll put all my money there. You'll know it's at least $15. And when I do that, I'll do it under Zafarius's name. I'll do it in his honor. Okay, Skip, gotcha. All right, guys, I'm really going to hang up this time. Y'all take care. Be safe. Be free. Be free. Free. Don't let people tell you got to wear a mask if you don't want to. Obviously, if you want to, do it. If it makes sense, do it. Don't tell people you have to take a vaccine, but if you feel like you have to, do it. But be free. Be free. Don't let the state tell you what to do. You are in charge of your life. You are not a slave, and you are not a product of the state. You are a free individual. Stay that way.